Welcome back. This is the legal prophet Legumba Keris candidate, and we are continuing with our jurisprudence. We are going to a topic known as customary law and its relevancy in jurisprudence. How has it been of relevance? So first of all, begin by defining what a custom is or what customary law is. Basically, custom is something that has been used for over time. It is something that exists within a certain group of people. For example, there is a custom of Imbalu that is within the Bagisu. Then customary law, this is the law that regulates customs. Remember, when we go back to our historical development of the law, we see the 1902 Order in Council that had to come up with the repugnance clause, that is of 1902, if I'm not mistaken, of 1920. It had to come up with a repugnance clause, which clause was a test of all customs that had to be practiced in Uganda to avoid this issue of some customs were against humanity, morality, among others. We see various cases such as Gwao ibn Kilimo versus Kisunda ibn Ifuti. We see the cases of Rex versus Amkeo. We see the cases of Bruno Kiua and other cases. So they all try to bring in the aspect of the repugnance clause. So we see that today there is a definition of customary or customs under section 1 of the Magistrates Court Act, which basically defines the same. You also have to look, or you have to befriend yourself to the various scholars or the theories. For example, we go to the historical. Remember, one of the sources of law of the historical school of thought was customs. So you go and see that the various scholars such as Sir Henry Maini, Von Savigny, who belong to what we call the historical movement or the historical school of thought, they all based on custom, showing that a custom or a law exists for some time and is applied there and then. So the analytical school, that is Austin, he had to come up with law, not law, its source unless it is recognized by parliament and judiciary. So to him, he says that law is not law unless, but rather it is a source, or custom is not a law, but rather it is a source unless it has been recognized by parliament or judiciary. So again, while you're writing your paper, you have to know there is what we call the judicial tests. What are the tests? What makes a custom a valid custom? We have seen they had to come up with the repugnance clause in 1902. But what did the repugnance clause aim at, or what are the tests that were incorporated in the repugnance clause? One, certainty. Certainty basically means that for a custom to be a valid one, it must be clear. It must be clear. The other one, it must not be against public policy. You know what public policy is? Public policy can be maybe in a certain community they do ABCD. So you should not come up with a policy that is, a custom that is against that policy. For example, if we know that in the Islamic sector there is no eating of pork, then why would you come up with a custom in that community that encourages eating pork? So the second test is it should not be against public policy. Then the other, it must be time immemorial, meaning that for again a custom to be valid, it must have existed for a particular period of time, meaning that it must not have started today or yesterday. It must have existed for some good time. Then it must also be practiced for some time. That is another test. You should not come up with a custom that is not practiced. No, practice that custom for some good time, then it will be a valid custom. Then it must be that one that enables enjoyment of peace enjoyment. Like, it must be that one that enables the people to enjoy their peace, meaning that it must not be against the peace of the people, or it must not be barring anyone from enjoying his peace. Then the other one, continuity. With continuity, a custom must be this one that does not only exist today or tomorrow. It must be continuing for some time. It must not be made for only the people today, but must also be thought of the people in the future generation. Then morality. It must not be against morality. That is very self-explanatory. You can look at the cases of Bruno Kiua. Was marrying a person from the same clan moral? No, it is not moral. Then it must be reasonable. Is the custom reasonable? Meaning that if it is not reasonable, then they will not, or it will not be a valid custom. Bring the case of Kisunda, Gwao bin Kilimo versus Kisunda ibn Ifuti. Look at the father. The father was being forced to pay taxes for which the son had eaten. Was it right? to pay for the debts of his old son. No, it was not a reasonable custom. So for that case, they had to say that it was null and void. That must not be against the law. Remember, a custom, when we go to the hierarchy of laws in Uganda, we shall see that customs almost rank the last, or are almost the last. So the law is superior, that is the supreme law, the constitution, the acts of parliament, the case law, among others. So custom must not be against the law, again, in order to say that it is a valid custom. Again, the other aspect that we should know is that what are the different classifications of customs. So in Uganda, all the various customary law, they classify customs into majorly two. There is what we call customs backed up by sanctions and customs not backed up by sanctions. So the customs that are backed up by sanctions are also known as the compulsory sanctions, and they include legal customs. Legal customs, these are customs that have been incorporated within the law and they are enforceable. There is also what we call the local customs, the legal customs enforced by law, and there is what we call the conventional customs. So the conventional customs, we are going to see that they are also known as the usages. For them, they are not customs, but rather the parties to the contract, or different parties to a various contract, will have to say that let us be bound by this custom. But by law, they are not customs, but the parties to the contract make sure that they are customs. Then when we go to the legal customs, they conform, or they include what we call the local customs. Local customs, these are customs that are practiced in a particular locality. For example, in Chazanga, in what each locality has its own custom. You'll find that in the Bagisu, Embalu is practiced, so it is their custom locally. Then there is what we call the general customs. These ones are customs that are practiced by the world at large or the country at large. Nga they are general, they are not only practiced by a particular clan or locality. Then let's go to what we call the limitations to customs. What are the limitations of customs? What limits a custom? There are three limitations of, or there are three tests that limit a custom to be valid. The first test is what we call the repugnance test. So the repugnance test, as I explained earlier, that is where a custom does not conform to morality, justice, and fairness, then it is not a valid custom. Bring the cases of Bruno Chihuahua, bring the cases of Gwao bin Kilimo. There is what we call the incompatibility test. The incompatibility test means that the customs are not incompatible, or they are violating the various laws that are existing at a particular time. So where the customs violate the laws that are existing at a particular time, then they are null and void as a result of the incompatibility test. Then the last test is what we call the public policy test. So the public policy test, this is where the customs are in violation of the public, or the public opinion, maybe then they would say that they are not a valid custom. So that is what we call customary law in jurisprudence. Thank you.